Welcome. My name is Peter MacDonald Eggers. I will be discussing with you today Section B of the Marine Insurance course, which is concerned with the duty of the utmost good faith. Before I do, I should just tell you a little bit about myself. I'm a barrister specializing in international commercial law with particular emphasis on insurance law, shipping law, and international trade law. I practice with regularity in relation to marine insurance law, so hopefully I have something of use to impart to you today. Now, Section B, as I say, is concerned with the duty of the utmost good faith. It's described often in Latin as the duty Uberrimae Fidei, but we often say good faith or utmost good faith as a shorthand. It's important because it's regarded as the signature characteristic of not just in a marine insurance contract, but all insurance contracts. And by virtue of its nature, which I'll discuss with you shortly, it's often received a great deal of criticism. Hence, there's a call for law reform in this particular area of insurance law. Now, before I discuss each of the topics which will be considered as part of Section B, I should just point out that each chapter in the section is structured in the following way. The chapter begins with relevant references, firstly to academic textbooks and other literature, and then it refers to the cases. And the more important cases are identified with an asterisk. Now, after the references are identified, then the chapter will move on to a discussion of the relevant legal principles and doctrines which can be extracted from a consideration of the authorities. And once you've mastered that discussion, then there is a summary identifying what you should have learnt as a result of your review of the chapter. And finally, to test your understanding, there is an activity or more than one activity and some feedback in order so that you can understand how these principles apply in practice. Now, the topics which will be considered as part of Section B are as follows. Firstly, the presentation of the risk by the assured to the insurer. Now, this risk is presented often through the medium of an insurance broker who will in most cases act on behalf of the assured as the assured's agent. Now, the second topic is closely related to the presentation of the risk, and that is concerned with the duty of the utmost good faith and how it manifests itself not only during the presentation of the risk, but throughout the relationship created by the insurance contract between the assured and the insurer. And the third topic considers the position of the insurance broker in particular. And unlike other commercial relationships, the position of the insurance broker, even though the broker is only an agent, has some considerable importance. And indeed, the Marine Insurance Act, which deals with the law of marine insurance generally, actually has special provisions which identify the rights and duties of the broker in connection with the Marine Insurance Act. So they're the three topics. Now, as far as the duty of the utmost good faith is concerned, this is a large topic. It accounts for the majority part of Section B, and it will begin with a consideration of the very nature and purpose of the duty of the utmost good faith. Now, put simply, it is this, that because of the nature of an insurance contract, and that's the nature which we'll have to consider when you review the section. But because of that nature, the law has considered that it's not sufficient for each party to beware its own position. So it's not a buyer beware scenario, but rather it's a scenario which imposes obligations of candor and openness on both parties. So it's not enough, for example, as would be the case with any ordinary contract, that either party should refrain from making positive misrepresentations. Insurance contracts impose an additional requirement that the assured and the insurer should volunteer full and accurate disclosure of relevant information to each other. And hence the name is the duty of the utmost good faith. It's good faith because of the candour required by both parties, and it's also regarded as good faith in the sense it's reciprocal. It's a mutual duty owed by each party to the other. Now, once the nature and purpose of the duty is considered, then we will move on to see how the duty manifests itself at each stage of the legal relationship involved in the insurance process. Now, the first and probably the most practically important aspect of the duty is that concerned with the presentation of the risk. This is sometimes called the pre-contractual duty, because it's a duty which is imposed upon the parties prior to and at the moment of the conclusion of the contract itself. And for this purpose, we'll be considering the duty as it falls upon the assured on the one hand and upon the insurer on the other hand. And the whole purpose of the duty is to ensure that there is a fair exchange of information between the parties so that they can enter into the contract knowing all the risks which may present themselves during the course of the insurance contract. Now, once the pre-contractual duty is considered, we will then move on to consider the post-contractual duty. Now, this is a topic which is contentious because there are some who consider there is in fact no post-contractual duty of the utmost good faith, although there are others, like myself, who think there is such a post-contractual duty. But the post-contractual duty is really most concerned with the presentation of claims under the insurance policy. And the duty in its most exact form requires the assured not to act fraudulently towards the insurer as part of the insurance claims process. Now, once we've discussed both the pre-contractual duty and the post-contractual duty, we'll move on to the question of the remedies for breach of the duty. Once you understand what those remedies are, you will begin to see the need for law reform in this area, because the remedies are unfortunately harsh as far as the assured is concerned, not in all circumstances, but in some circumstances. And in addition, it's one-sided in favour of the insurer. Once we've considered the risk presentation process and the duty of the utmost good faith, the section B, will conclude with a consideration of the position of the insurance broker. And the chapter concerned will, of course, consider the broker's duties as regards the duty of the utmost good faith, but will also extend beyond that to consider the broker's wider duties. Now, I hope once you've reviewed all the chapters in section B, you will gain a full understanding and enjoyment of the law of good faith as it applies to insurance contracts.